Good afternoon to all. Welcome to Digital Learning, Department of Collegiate Education. Here myself, P.Ranganayakulu, Assistant Professor of Commerce, Government First Aid College for Women, Tumkur. Today, I would like to explain the sources of Indian business law, part 2. So in the seventh session, in the earlier video, I explained the sources of Indian business law, part 1, and the remaining sources of Indian business law I would like to explain in this video. The other sources of Indian business law, which includes the statute law, the law merchant, and the writings and opinions of scholars. So in the seventh video, the customs and usages, the common law, and equity, these are also the sources of Indian business law, and I explained already. And let us see in this video the fourth, the sources of Indian law, that is the statute law. The statute law means it is an acts of parliament. These are the most efficient and the most usual way of bringing about the changes in the law today also. The authority of the parliament is supreme and subject to natural limitations and those laid down by the constitution. And whereas the statute law, which includes the Indian Contract Act of 1872, the Sale of Goods Act of 1930, the Companies Act of 1956, the Indian Penal Code 1860, the Indian Evidence Act of 1872, and the Code of Criminal Procedure is 1973. So the statute law, so let us come to know the meaning of the statute law. So the statute law, it means the acts of parliament, the acts which are made by the parliament with the approval of, with the recognition of, with the assent of the president of the country. All that laws are called as the statute laws, and these are the most efficient. And if the statute law is approved and recognized by the governor of the state, that is also called as the statute law at the state level. And if it is approved and recognized by the president of a particular country of India, president of India, that law is also the statute law at the central level. Here we can observe the two types of statute laws are the center, statute law at the center, and as well as the statute law at the state level. The statute law at the central level is the law if it is approved by the president of India. And suppose if the any law, if it is approved by the governor of the particular state, that law is called as, also called as the statute law. So therefore these are the statute laws are the most efficient and most useful way of bringing about the changes in the law today also. Because why we can say that they are the efficient and most usual way of bringing? Because the assent of the governor and the approval of the governor and approval of the president is required to bring that act into implementation and in order to make the law. So therefore it is the efficient and the most usual way of bringing about changes in the law. Then next, the authority of the parliament is supreme and subject to natural limitations and those laid down by the constitution, and at the time of formation of the law and at the time of making of the law by the parliament, they have to be observed, they have to be considered the Indian constitution, which provides, because we can observe the three types of governments, that is the judiciary system, executory system, and also the legislation. So therefore the Indian constitution, it plays the more important role, and keeping in mind the Indian constitution, then they have to be frame the laws, they have to follow the rules and the regulations of the Indian constitution, and then that will be implemented and that will be enforceable by law. So therefore it is what are the limitations that are prevailing in the Indian constitution, and what type of rights that are provided to the society, and keeping in mind the interest of the society and the limitations of the constitution, the statute law is to be made by the government, either it may be the central government or maybe the state government. They are not to be neglected the constitution, and the constitution, it is a framework for us, and based on this framework and within the framework only, the law is to be made by the government, by the parliament. So therefore, why? Because it is the supreme authority, the parliament is the supreme authority, and even though it is the supreme, and the supreme authority is also to be considered the Indian constitution, keeping in mind the limits that are prevailing in the Indian constitution, and within that limits only, that a statute law is to be made by the government, by the parliament, or by the central government. So therefore the statute law is also one of the important source of business law. Therefore the statute law, it means it is an act of parliament. So this is the law which is made by the parliament, and these are the most efficient and the most usual way of bringing about the changes in the law today also. The authority of the parliament is the supreme and subject to natural limitations and those laid down by the constitution. ಇದರ ಪ್ರಕಾರ ನಾವೇನು ಅರ್ಥ ಮಾಡ್ಕೋಬಹುದು ಅಂದರೆ, ದ ಸ್ಟ್ಯಾಚ್ಯೂಟ್ ಲಾ ಈಸ್ ಆಲ್ಸೋ ಒನ್ ಆಫ್ ದಿ, ಇದು ಕೂಡ ಒಂದು ನಮಗೆ ದ ಇಂಡಿಯನ್ that is for the Indian business law, this is also one of the important source. ಇದು ಕೂಡ ಒಂದು ನಮ್ಮ ಇಂಡಿಯನ್ ಬಿಸ್ನೆಸ್ ಲಾಸ್ಗೆ ಸ್ಟ್ಯಾಚ್ಯೂಟ್ ಲಾ ಅನ್ನೋದು ಒಂದು ಮೇನ್ ಸೋರ್ಸ್ ಆಫ್ ಲಾ ಆಗುತ್ತೆ. ಸೊ ಅದಕ್ಕೆ ಪಾರ್ಲಿಮೆಂಟು ಅಟ್ ದ ಟೈಮ್ ಆಫ್ ಮೇಕಿಂಗ್ ದ ಲಾ, and they have to be considered the Indian constitution. The Indian constitution plays the most important role in the law making. Therefore they have to keep in mind the constitution, and they have to lay down by the what the constitution it is laid down the rules and regulations, and within that rules and regulations only the law is to be made by the parliament. So therefore that is called as the statute law. Then let us see the examples of statute laws in India. So here there are the acts which are given to understand the examples of the statute laws. Here the statute law, which includes the Indian Contract Act of 1872, and it is made by the Parliament, Sale of Goods Act of 1930, the Companies Act of 1956, Indian Penal Code 1860, Indian Evidence Act 1872, the Code of Criminal Procedure 1973. These are all the important statute laws in India. And here the Indian Contract Act, it is very very important, and if you wants to enter into any contracts between the parties, and both the parties, both the promisor and promisee, have to be considered the rules and regulations prevailing in the Indian Contract Act of 1872. And so also the Sale of Goods Act, it consists of the rules and regulations for the buying of goods and services, and the goods, that is called a Sale of Goods Act, it is applicable for the purchase and sale of goods. So therefore both the buyer and seller have to observe the rules and regulations which are consisted in the Sale of Goods Act of 1930. So also the Companies Act, it is very very important. The Companies Act, it lays down the rules and regulations relating to the formulation of the companies, registration of the companies, and etc., the issue of securities and everything. And the Indian Penal Code, that is also one of the important the statute law. The Evidence Act 1872 is also one of the important the act. It is made by the Parliament. This is also one of the statute law. And so also the Criminal Procedure Code 1973. This is also very very important act. So therefore these are the statute laws. So they are very very important. These statute laws are the one of the sources for the business law, Indian business law. So therefore the Indian business law, at the time of making the Indian business law and the framing of the Indian business law, at the time of making of the law relating to the business, and they are followed all these statute laws. Next, the fifth important source of the Indian business law, which includes the law merchant. So what is called the law merchant? Since the beginning of 14th century, merchants in England have started to develop the mercantile law and usages on the basis of mutual conduct, and also started to develop tribunals to settle the disputes on the basis of mutual understandings. Therefore the law of merchant is a set of principles established by courts during course of the settlement of disputes in the court, and collection of rules made by the merchants during the course of business conduct. It is also one of the major sources of business law. So here let us see what is how the law merchant plays, or how it is important as one of the source for the business law. So the law of merchants is a set of principles. So what is called the law of merchant? Law of merchant is it is a set of principles, and the principles are established by the courts during the course of the settlement of disputes in the court. So therefore it is one of the set of principles that is called as, and the principles are established, the principles are made by the courts during the course of the settlement of disputes in the court. ಅಂದ್ರೆ ಈ ಪ್ರಿನ್ಸಿಪಲ್ಸನ್ನ ಕೋರ್ಟಲ್ಲಿ ಜಡ್ಜಸ್ನು ಕೇಸಸ್ನ ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡೋಂಥ ಸಂದರ್ಭದಲ್ಲಿ ಡಿಸ್ಪ್ಯೂಟ್ಸ್ನ ಸಾಲ್ವ್ ಮಾಡೋಂಥ ಸಂದರ್ಭದಲ್ಲಿ ಮತ್ತು ಕೇಸಸ್ನ ಡಿಸ್ಪೆನ್ಸ್ ಮಾಡೋಂಥ ಸಂದರ್ಭದಲ್ಲಿ ದೇ ಆರ್ ಅಬ್ಸರ್ವ್ಡ್ some of the important points, and keeping in mind those, they are prepared some of the set of principles. That set of principles are called as the law merchants, which are established by courts during the course of the settlement of disputes in the court, and the collection of rules made by the merchants during the course of business conduct. And also the not only that is called as law merchant contains the principles or the set of principles which are established by the courts during the course of the settlement, but also, and they are collected some of the rules made by the merchants during the course of their business, at the time of doing the business. It is also that is called as law merchant prakara, how the law merchant will become one of the major source of the business law ಅನ್ನೋದಕ್ಕೆ ನಾವು ಅರ್ಥ ಮಾಡ್ಕೋಬಹುದು. ಕೋರ್ಟಲ್ಲಿ ಕೇಸ್ ಡಿಸ್ಪ್ಯೂಟ್ಸ್ ಸೆಟಲ್ ಮಾಡೋ ಅಂಥ ಸಂದರ್ಭದಲ್ಲಿ some of the principles, some of the that is called as rules and regulations which are observed, which are the principles are observed by the judges, and that keeping in mind those principles, and they are collected some principles, and not only that, and the rules, some of the rules which are made by the business peoples during at the time of doing the business by the business peoples, what they are observed. So therefore the rules which are observed by the business peoples and the principles which are observed by the judges at the time of settlement of the disputes, both are the formation of the law merchant. So therefore the law merchant is also one of the very very important sources of business law. And the last source of business law, which includes the writings and opinions of scholars. So what is called as the writings and opinions of experts or jurists are also called juristic law, because juristic writings have played the important role in the development of business law. The opinions of jurists or the experts helps to give the proper instruction for lawmakers where existing law is not sufficient, and it also helps the judges in the course of making verdict when there is a vacuum of the law. So opinions of jurists or the legal experts is regarded one of the important source of business law. So let us see how the writings and opinions of scholars is the important for the business law. So here the writings and opinions. So here the that is the opinions of the experts, that is called as are the jurists, the law experts, that is are called juristic law. So what is called as the juristic law? The juristic law is nothing but the writings and opinions of the experts or the jurists is called as the juristic law. The whatever the opinions of all the jurists are the experts of the law, and also their writings which are given, that writings and as well as the opinions of the experts or the jurists is called as the juristic law, because juristic writings have played important role in the development of business law. The opinions of juristic peoples and the opinions of the experts of law is played an important role in the development of the business law, which helped a lot for the formation of the business law and also in the development of the business law. The opinions of the jurists or the experts helps to give proper instruction for lawmakers, because here we can observe these two peoples are the jurists or the experts in the law. Therefore they are discussing with each other and they are giving some opinions for the lawmakers, for the business lawmakers, and keeping in mind the opinions of the experts, then the business law is developed and made. So because it is the opinions of the experts is plays a very important role in any field for the development of any rules and regulations, or for the making of the rules and regulations, rather than the peoples, those who are not having any knowledge in the field of a particular subject. So therefore if we are not having any enough knowledge in a particular field, and it is better to obtain the opinions or the that is called as the knowledge, that is it is better to share the knowledge of the experts, and therefore the opinion of jurists or the experts helps to give the proper instruction for the lawmakers where the existing law is not sufficient. If where there is no the satisfaction for the jurists or for the law experts, then wherein the experts and as well as the jurists have given the opinion, and where there is no existing law, and if it is not sufficient, and if they are not satisfied with the law relating to the business law, and if it is not sufficient for the business law, and they have been given some their experts opinions, and therefore it also helps the judges in the course of making verdict. Means ಅಂದರೆ ಒಂದು ತೀರ್ಪನ್ನು ಕೊಡುವಂಥ ಸಂದರ್ಭದಲ್ಲಿ verdict means ತೀರ್ಪು ಅಂತ. So it also helps the judges in the course of making verdict when there is vacuum of the law. If there is no if there vacuum means ಶೂನ್ಯತೆ ಅಂತ. So therefore if there is no any particular idea or the knowledge about a particular subject at that time, it will be helped a lot, that is the writings and opinions of scholars will be helped a lot to the judges for the for giving of the verdict in the court of law. So therefore the opinions of jurists or legal experts is regarded as one of the most important sources of business law. So therefore it is better to take the opinions, and as well as it is better to take the knowledge of experts at the time of doing any something acts. So therefore it will be helped a lot, and it gives the more importance for the making of the rules and regulations. So therefore these are the that is called as the law merchants, and as well as the statute law, law merchants, and as well as the opinions of the writings and opinions of the scholars plays an important role in the business law, and they are very very important sources of the business law. Therefore we can observe what are the important sources of business law at the end. Number one is the important source of business law, which includes the customs and usages, common law, equity, and the law merchants, and the statute law. And whereas the lastly we can say that the writings and opinions of the scholars, and among all these the English law, and it is the foundation for the making of the Indian business law. The English law, the English mercantile law, it plays a very very important role in the making of and also in the development of the Indian business law. So this is about, these are all the various sources, and with the help of all these sources, and we have to understand what is the importance of all these sources in the Indian business law. Thank you for listening this video.